some hearing loss. It's not due to me. Well, my wife likes to jump on me sometimes about screaming, and so I should blame her, but I won't do it because we've been married 40 years. We started dating when we were 12. We named our child at 13. This is true. We were next door neighbors. Got married at 18, had him at 19, named him that name, got 40 years in, and he's practicing law with me right now. So sometimes it works, but I don't encourage that for my two granddaughters that are 10 and 6. I said, y'all need to wait a little longer. don't do like Pop. They can call me Pop Pop because I'm jumping around all the time. I said, don't do like Pop Pop. I don't know why I threw that in, but it's a good story anyway. So what they did on the hearing loss cases before, like I said, if you had a hearing loss, if you had 1% or 2%, you could get a total under occupational disability. Then they tied it into the AMA guidelines, and Governor Patton actually called down and asked Elvis Thompson. He's a Pikeville guy that does eye, ear, nose, and throat. He's passed away now because he was a very well-respected gentleman. So he called down and said, when does a hearing loss become such that it interferes with somebody's ability to do their job in the mines or anywhere else? When, what level, what threshold? And Elvis said, well, I think about 7 or 8%. So all of a sudden the law said you got to have 7 or 8% before you get a hearing loss. So if you're below 7 or 8%, you get your medical benefits paid and a hearing aid if you need it, but you don't get any type of compensation unless you're over that threshold. And that's where that threshold came in. And it's stood the test of time. It's been challenged in the Supreme Court 4 or 5 times, but it's upheld, and that's just the way it is. Have they been told about the black lung, about the unconstitutionality of that?
I think they touched on it, but go ahead and
Okay.
talk about it again.
On black lung is always a political hot button issue in eastern Kentucky, West Virginia, all the coal fields, okay? And we have, a miner can file 2 different types of claims. You can file a state black lung claim, and you can file a federal black lung claim. This is one of the few areas of law where a person can file 2 separate suits for the same thing. Usually you just get sued once, and that's it, and you're done, okay? But on this one, you can file a state case and a federal case. I do a ton of federal black lung work. There's no statute of limitations. People can file over and over and over again, even if they lose. They can lose 10 times. I've got one gentleman, I'm on his 12th claim. We've been going since like 1985. He hadn't worked since 85. He thinks I represent him because he doesn't have a lawyer, and I'm the one who shows up at the hearings all the time with the federal judges. And he's the nicest old gentleman ever was. He sent me a Christmas card. I mean, I really like him. If I could tell the insurance company just pay it, I would, but he didn't qualify. I didn't want to say, well, pay it, and he didn't qualify. But he's on like his 12th claim, and he's put my kid through college and everything else. I said, I appreciate that, Fred, but you need to quit. And they don't have to have a lawyer. They can just file. And like I said, no statute of limitations, and you can file as many repeat claims as you want. So that's a really funky kind of law. I mean, how do you ever close your books? If you're a coal company, how do you ever get a liability check on when you're done? Because you're never done. Because people can come back from 20 years ago that you haven't heard from. So that federal is a really different animal. Now the state black lung, we were using doctor panels, okay? And that was a pretty good way to handle it. In other words, the doctors can read the x-rays and tell us whether somebody's got black lung. And we don't need the judges and lawyers messing up the system. Let's get a panel of 3, change the panel around of experts who read black lung every day that are certified by the federal government. If 2 of the 3 doctors agree, that's what we do, which is about as fair as you can get, as long as you don't have a panel stack. If 2 of the 3 doctors agree, we're done. And that's what we did. We went on that system for the last 10 or 12 years. And, of course, the B readers, when they're looking at the x-rays, they're not looking at CT scans or anything. It's x-rays only. And about 89 to 90% of the time, 2 of the 3 agreed. Most of the time, 3 of the 3 agreed. So that makes it, pretty reliable system to me. I mean, it speaks like it's okay. Well, a lawyer down in western Kentucky, Dick Adams, before he passed away, Lord, I'm getting old. All my buddies are dead. I'm next. Oh, but I'm saving my psychological claim. I know I'll get one sometime. If I got to have a direct injury. He decided he's going to try to get this declared unconstitutional for due process reasons. And his whole argument was, we've got a person applying in Ashland who works in a foundry for pneumoconiosis. There's different types of pneumoconioses. It's not just coal. There can be all different types of pneumoconioses from dust exposure, okay? So the person that's over here in the foundry in Ashland does not have to go through this panel. He can just have one doctor say he's got it, then off we go, and we're to the races. But the coal miner has to go through this more stringent standard, okay, of this panel. So this guy is going to probably get denied, and this guy is probably going to get something over here for the same medical condition. It's just not coworkers, but it's pneumoconiosis. And he doesn't have to go through the same procedure. So the Supreme Court of Kentucky got a hold of it, and it's Will T. Scott. He wrote the opinion. He's another good neighbor of mine and a Supreme Court justice from down in Pike County. He swore me into the Alaska bar, too. He loves Alaska. And so Will T. got 3 other justices to agree with him just recently, and 3 of the 4 said it's unconstitutional. You can't treat a miner any different than the other person in the foundry applying, and they have to go through the same procedures. So what happened was we had about 300 or 400 cases that had been filed that have been sitting there waiting for this opinion to come out, because there's nothing we can try until we know what the law is, okay? So they ruled it was unconstitutional, said it's gone. So we asked for a petition for rehearing. That just got denied last week. So now we're going to have about 300 or 400 cases come out of that system. Whack! It's going to hit our system all at once. The question is, what law do we apply? We don't have a law. It's unconstitutional. What do the lawyers and the judges do? Well, according to law, we're supposed to go back to the way it was before the law was declared unconstitutional. So if we go back to that, then the person in Ashland will be treated as the same as the person in the coal mines. The question is, what will that do to the awards? We've got judges now that are brand new. We've got a whole new slate of judges, very young. I call them young Turks. They don't know what black lung is. They wouldn't know it if it bit them in the head, okay? So we're going to have people deciding cases that don't have a clue what's going on. So we've got a real training process here that we're going to have to do. And Dwight's going to have us up, and I'll come up, and some people from the other side who've been doing it for years. We'll bring some doctors in, because we're going to have to train them to do the right thing. And they just won't know. They're going to be sitting down there. They're going to have 2 doctors now that say this person's got black lung, 2 that says he doesn't have black lung. They're looking at a guy 50 years old who's not going back to work in the mines. They're going to give him an award, whether he's got it or not, okay? That's just what's going to happen. So what do you think is going to happen to the volume of claims that are going to happen? My buddy McKinley Morgan, I just finished up with him today, but I think, unless rumor is wrong, and it may be, you know how the rumor mill is, he's got about 150 or so, 200 cases he's sitting on that he's going to file as soon as he finds out how to file them. He doesn't know how to file them. He doesn't know what procedure to go by. Now that may not be true, but if it does, we're in a real world of hurt. He filed one the other day where the guy had not worked since 2004. Okay, this is a state case. It's supposed to be, on a state case, it's 3 years up to 5. The most you can go is 5 years without filing your claim. He hadn't worked in 7 or 8 years. So I filed an immediate motion to dismiss. I said, this guy hadn't worked in 7 years, statute of limitations run, case should be dismissed immediately. McKinley writes back and says, oh, no, Paul. He said, if the law is declared unconstitutional, everybody that ever could have applied that didn't gets to file now, and there is no statute of limitations. And that's going to be his argument. If he wins, everybody will file, okay? If he loses, that'll shut the door on those older cases that are gone. So, I mean, it's an ingenious argument for him. I don't know that he'll win, but it's going to be a lot of fun. I love Supreme Court cases. I mean, when I go up there, they said, there's old War Horse Jones. They call me a War Horse. You know, leave me alone. I'm just a little old. So that's what's going on with the black lung right now. It's been declared unconstitutional. All those cases will be coming out. It'll be very interesting to see how they all shake out. I really can't predict. But I can tell you the coal industry is getting a little nervous. I can tell you that right now. Yes?
Why do they not, in black lung cases, take into consideration smoking?
They do. Smoking can cause a breathing problem, but it doesn't cause the nodulation on the x-ray. Only the inhalation of the mineral dust causes those little nodular densities to appear. Now, whether those nodular densities cause you a breathing problem, that's the question, because if you've got a breathing problem and it's primarily due to smoking, but dust also contributed a little bit, what do you do with those cases? And that's the question. You know, federal black lung now, they're paying everybody. If a doctor says, even if the x-rays are negative, if the doctor says the inhalation of dust contributed to the COPD, even in part, even if smoking is 99% of it, you're going to get an award. Now, to me, that's ridiculous. I mean, you ought to apportion out. If the doctors and the judge believes that 80% is due to smoking, well, let the cigarette industry pay 80%, let the coal industry pay 20%. I mean, that just makes sense to me. and let them pay 80% of the medical bills for the cancer and stuff that they caused. We didn't cause it, and let us pay what we're supposed to pay for. But the federal government doesn't like to make sense sometimes. I'm sorry I'm on tape, but now I'll get audited. But but they're supposed to take it into consideration. Under the state black lung, it's based on nodulation, which is what is black lung. On the federal, it's based on breathing. And you all know, if you smoke cigarettes, you're going to get COPD. I mean, a lot of people won't, but the majority of people are going to get COPD. And if you've been both a minor and you've also been a smoker, 20-pack or 2 packs a day for 40 years, and the inhalation deaths contributed very little, what's the right thing to do, you know? So that's the debate we have on our federal program. Right now on the university evaluations, were you all told about that? That's, okay, when we talked about what the system will go back to, before we had the panel and the people from the foundry in Ashland, they had to go to a university evaluation. We brought the University of Kentucky, and the University of Louisville into the litigation process because the thought was Paul Jones can't buy the University of Kentucky and Johnny Turner can't buy the University of Louisville. They should be objective, educational, medical institutions that should tell us the truth if somebody's injured or not. So all the injury cases, if there's a question between what the condition is, go to a university evaluator. They'll go to UK or U of L randomly, and then that university evaluator is given presumptive weight. I can reverse what it is if I can show there's a good reason for that university evaluation is improper. And I've reversed 100 of them, okay? So that's what will happen to the black lung cases now. The black lung cases now, all that have been sitting in abeyance are going to come out, they're going to go to the university evaluator, and we're going to have a whole new system. But that means we're all going to be having all kinds of new depositions because most of them we'd already had our medical proof done. So now the problem was UK and U of L didn't have the B readers anymore because they weren't being used for the black lung program. It was private. Now we're going to have to get a bunch of people hired through the UK and through U of L that can do these evaluations. So we're kind of stuck there until we get the doctors. Dwight's working on that. And hopefully we can bring some folks in that really know what they're doing, maybe from University of Vanderbilt and some other places, and let them kind of contract with the universities. We'll see how that works. Reopenings, if you have an injury, okay, and you get worse, you have in Kentucky 4 years to reopen your case. And the logic behind that is after 4 years, you should know where your condition is. You should either be stable or not. Now, every now and then there may be something different, but if you have an injury and you get an award or you get a settlement, there's 4 years to reopen that case. I had a reopening case today, and the lady said that she'd hurt her foot and she had a left ankle sprain or strain. Now she says she's got RSD and all kinds of problems going up her leg, so we're litigating that as to whether there's been a progression of what her problem was with her foot. But you got 4 years. The plaintiffs' bar, they are always pushing, and if you ever get involved with workers' comp, they want 6 to 8 years. They just always want a little bit more, and we always just want a little bit less. And we usually somewhere meet in the middle. Bad faith litigation, we don't have a whole lot of that. That was one of the questions that the lady in the back asked, and that's the sanctions. Every now and then some companies do things they're not supposed to do, okay? And when they do, they'll get slapped. Dwight will slap them in the hand. He'll call them up to Frankfurt. He'll read them the riot act, and he'll remedy the situation, which is what he should do. But most people do what they're supposed to do. Lifetime benefits. Before the law was enacted in '96, people got lifetime benefits. So that means they drew for life. That 22-year-old or 28-year-old I told you about, Chuckalina Kinney, he's still alive. He's down in Florida on a houseboat. He's drawing workers' comp. He'll draw it for the rest of his life because he was so young. I mean, and he's on the lifetime benefits. I think that was his name because I didn't think I'd ever forget that name. And but what happens is Social Security kicks in, you know, at 65 and 66. So what they decided to do is say, you're going to draw workers' comp benefits until you reach old age Social Security, then you're going to get your Social Security. So they cut off now at age 66. Most people now, if one of us get hurt, we would draw benefits till we're 66, and then we're on our Social Security. So that's the way those benefits would work. They want to go back to lifetime benefits. I don't know if they ever can. The plaintiffs' bar, because just can't afford it. The state of Kentucky just can't afford it. The definition of injury and disability we've talked about. Hearing loss we've talked about. A big thing now that's going on is safety penalties. If a worker gets hurt and it's because an employer violated a safety penalty either under MSHA, OSHA, whatever regulation, the employee can get a 30% increase in their award. Now, that's big time. If you're getting $500,000, you get a 30% increase, that's a lot of jack, okay? And as you all know, or you may know or may not know, if you're reading the papers from Eastern Kentucky, our mines are getting saturated with violations now. We're getting hit with violations, and a lot of it had to do with the explosion over in West Virginia and the various issues that are around there. But then the good mines get penalized. And that doesn't mean that they weren't a good mine, and the Massey thing I'm not even going to get into. But a safety penalty is very, very expensive. And the problem is any given day, just like at my law office, an inspector could come in there and find I've done something wrong. I don't have a fire extinguisher up, or I didn't do this, or something that's a violation of something, okay? So these people are getting drilled. One of my law partners, Billy Shelton, all he does is environmental work and mine safety stuff, and does these violations. He's so busy right now, he can't turn around. I mean, they're calling every day about unbelievable stuff. And some of it is legit, but a lot of it is picky. And I'm all for safety. I believe in safety 100%. I told you, when I left my senior year, before I took the GED and went on to college and law school, when I was married, I worked in the mines for a little while. It's hard work, and it can be very dangerous, okay? But after I worked a little bit, I said, I'm going to college and I'm going to law school, and I'll see you all later. And I left and didn't come back till I was a lawyer. And but I respect those people tremendously. They have my total respect because it's hard work. So that's the safety penalty issues. We're having a lot of those now, and we're trying those along with our workers' comp case. So now we're back to the cases like we used to have in the past. When somebody comes, let's say it's a coal miner, and I'm not picking on miners. Like I told you, I respect them completely. But if somebody comes out, they'll now file a black lung case under this new procedure they'll get. They'll file a hearing loss case. They'll file a wear and tear case. If they have a specific injury, they'll file an injury case, and they'll file a psychological thing and tie it into the physical injury. So we're back to people having 5 and 6 claims instead of having one claim that what we're really there for. And I don't think that's a good system. But that's just my personal opinion. And I am a defense lawyer, but I try my best to be fair. When somebody's legitimately hurt, I totally believe in paying them. Totally. Exactly what they're worth. But if they're not hurt, they ought to be back to work just like the rest of us. That's just the way I feel. That's just my personal opinion. All right. Any questions?
You seem to be pretty up to date on a lot of the stuff. Is there any particular website or particular place that a person can go to get the latest changes in the laws and things online or anything?
For workers' comp?
Yes.
Yeah, go to Kentucky Courts and pull up workers' comp. Or you can go to the Kentucky Workers' Compensation Board. They'll have all changes. Or you can go to a website called CompEd. CompEd is a program that we lawyers are involved with, which gives you every new law, every new Supreme Court opinion. It summarizes it all for you, and it's done by a fellow named Ched Jennings up in Louisville.
Okay, and can you sign up for like emails that will put out updates periodically?
They just have a database. Once you see it, you can just call him. It'll give you a number that call him, just tell him you want to be on his database, and whenever he does anything, it goes out to everybody. Just mass, whatever you call it. I'm just now getting into all this stuff. They made me do this stuff. I said, I don't want to do this email and all this stuff. They said, Paul, you got to do it. I said, okay. So now I'm doing it now. I love it because now I can go to Georgia and down at my condo, and I can sit on the beach and have a cold beer, and I can sit there and they're scanning me all my medical reports and all my stuff, and I'm just writing back, send it here, do this, and I can practice from down there. I said, this is cool. I really like this stuff. And it is fun once you get into it. But us older folks, I always said God only lets you live so long because you can just stand so much change. And then it's time for the next generation to come in. But, every now and then you just got to pull your bootstraps up and go.
I don't know whether it's true or not, or maybe I'm getting confused, or maybe I'm confused, but I read that there's a lot of disability claims by police and firemen, that something like 67% when they retire, they're on some kind of a disability. Is that true, or is that something to be concerned about?
Where I'm down in Pikeville, we only have about 6 people in our police department in Eastern Kentucky. I have read that in the papers from up here. Whether that's true or not, I don't know, because I'm just not up here practicing this. It wouldn't surprise me though. That, that's a pretty dangerous occupation too, and it wouldn't surprise me now. I would assume that the judges would weed through the cases that shouldn't be paid. But now, you know, the police and the firefighters may have their own disability system outside of workers' comp. Yeah, yeah. And now I've heard that. Now, whether it's true or not, I really just don't know. But I can find out. Remind me to find out, and I'll let you know.
And lastly, in part of our assignments, we looked at these videos where Dr. Crystal and a gentleman from Detroit, I can't think of his name, were given depositions. And all the lawyers asked him what they were being paid, how much they charged to do the assessments. I'm just wondering what was the relevance in that?
For the jury, when you go in front of a jury, if I'm asking him those questions, I never do it because I think it's, I think, yeah.
You won't be asked that in workers' comp.
No.
It doesn't matter.
In court cases, they want to portray him as a hired gun. So anything they can do to chip away at his credibility, even if it's one thing that gets one juror starting to think, because you got 12 of them on there. So all you got to do is get one juror saying, well, you know, Dr. Crystal made about $5,000 off his case. Why should I believe a thing? Because he's just hired gun. That's the reason.
So that's a legitimate question?
It is a legitimate question. I don't ask it because I think a jury is smart enough to know that he's getting paid and getting paid by me. I don't, you know, but that is a legitimate question. But I never do ask it. Because I'd rather jurors be my friend rather than they would be saying, well, you're just as bad as he is. And not that he's bad. Do they ask you that all the time in your civil cases?
Sometimes, you know, that cuts both ways, because if one side asks, the other side can ask.
Right.
It all gets neutralized.
Yeah, they're all getting paid. This isn't a free ride. What do you charge?
Want the fee schedule?
Yes, ma'am.
Settle 90% of your cases.
We do. Now, not our federal black lung, we're not allowed to settle those, but of our state workers' compensation cases, about 90%, me personally, I settle about 90% of them.
So the other 10%, when people are paid, when they win the plaintiff's side, is there just like a lump sum amount that they get, or do people actually get that $25 a week?
Yeah, they get a weekly benefit, whatever it is, whatever their percentage is, they'll get a weekly benefit. Most of the time, if it's not a total, it's paid for 425 weeks. So they'll draw $50 for 425 weeks a week or whatever it is. A lot of times, if I lose a case like that, then I'll just go ahead and write the plaintiff's attorney, say, here's what the value of that case is, let's discount it down, and let's let us pay you a lump sum, you sign waivers, and we're gone. So most of the time, we just go ahead and do that, because people, you know, it doesn't, $50 a month if you're not working is not helping you much, you know. And you need that money to help get your bills paid, get you into your Social Security case, and get your life moving on. Because it can become a very financial strain, very.
And then another question I have is, there's a lot of minors who work well into their 60s and 70s. So if they came out with a work comp claim and they were, say, 68 years old, would they still get their work comp, their
2 years.
for 2 years?
For 2 years.
And then it would roll over to their Social Security?
That's correct. If you file after age 65, they give you a 2-year window. And it's not much. I mean, you know, if you legitimately have, but you know, your Social Security's kicking in, and that's what the state of Kentucky said, we just can't afford it anymore. So that's what they're doing. This is a lot of this, gang. I think you've seen is politics and economics. I mean, that's what it is. When some other administration comes in, if they want to loosen it up, they'll loosen it up, and more people get more money. And then the industry will be crying and screaming and hollering, saying we're broke, and then somebody else comes in and they'll go back the other way. I just wish they'd get it right. And I think they're trying, but it's just hard to, you have so many competing interests. There's so much money in workers' comp. I mean, it's like, what were the figures I told you? It was like 100 million or 200, whatever it is. It's millions and millions and millions of dollars. When you throw millions of dollars in a pile and you got lawyers and judges, everybody else feeding off that, it's a frenzy, okay? It's a lot of money, a lot of money.
We was talking about, and she asked a question, but you said they switch over from workers' comp to Social Security at 66. Okay, that's people that retire at 65. Now, over the last 10 years or so, they've increased the retirement age. For people that retire at 67, now does it go to 68? Does that increase it?
Yes.
Okay.
Yes, yes. And it should. It should.
Okay.
Question on
when you talk here about your definition of injury, and not including the effects of the natural aging process, how do you determine that? I mean, you know, if someone injures their back, you know, in a court, how are you gonna make that distinction that this was natural aging process or this is a legitimate injury? So, you know, the
The
definition doesn't
doctors
seem
do.
to me to help at all,
Yeah.
you know.
The doctors do that, and here's what the court cases that have come out after that. At first, the doctors would say, when we first started this process, well, we feel natural aging process is due to 80% of this person's problem, and 20% is due to that little lifting incident. And we were apportioning awards out at that time. The court said, that's ridiculous, what we're going to do. And basically, they just said, it doesn't matter about natural aging. They said, if somebody bends over and they arouse that natural aging process by a work-related injury, we're going to make that compensable. So the legislature, just like in the Watson case, the judiciary, just like in the Watson case, basically wrote out, even though it says you don't exclude natural aging, now they're making them compensable again. But you have to have an arousal of that by a work-related incident. That's the only thing they can figure out what to do. When we get into definitional things, it's a lot different sitting in a room and we're all talking about it than when we're talking about somebody's back and their head and their neck. What else? Geez, y'all, come on, free legal advice. You don't get this very often. Divorce, anything? Oh. No, you're limited. That's the key for the employers. They have a fixed liability, that's what it is, so they know going in. And if you didn't have that, we couldn't have our insurance rates set. We have people outside of the state, NCCI, these think tanks from all over that set workers' compensation rates for all the states. They'll come in and look at our law, rate it, and then that's what you are. They'll look at mining, they'll look at lawyers, they'll look at dentists, and they'll rate them as a classification, and that's the compensation that I pay for a premium. So that's the way it works. If they had punitive damages, we could never get to what the premium needed to be. And we have to have, you know, if you work in Kentucky, if you're an employer, you're required to carry workers' comp on your employees. You're required. If you don't do it, you're going to get in real trouble. And you want to anyway, because if somebody gets hurt and they come after you personally, you got a real problem. Because, you know, if you have to pay somebody's medical bills now, I don't know if you all were told about the medical side. Medical bills are now over 70% of the money going out in workers' comp. It's not going to the injured worker. It's not going to me as lawyers. 70% is going to medical. We are having people, we're having stuff that's just getting milked, okay? And a lot of people are on narcotics, and a lot of people want to just get on their workers' comp so they can get their lower tabs and their lower set. I call it the legalization of dope, and it is. And I've seen it happen 100 times, and I've seen all kinds of people that weren't disabled. By the time they got finished going to these doctors and getting all those drugs, they were disabled, okay? And that really just burns my tail. But it happens. It happens. And that's the system. Sometimes, you see why I'm bald? This has driven me nuts.
You mentioned the drugs. This has always concerned me. If someone's injured on the job, they're in terrific pain, the doctor gives them OxyContin. They follow it exactly as prescribed, but they become addicted. They can go back to work if the doctor approves of a maintenance dose like the old methadone, but they don't let them do it anymore. Is there anything that helps that type of individual?
Not that I know of.
Just like a person can take a shot of alcohol and be fine, where another one could all of a sudden become an alcoholic. So I'm not talking about the ones that sells the drugs or
Right.
pushes that are in.
You're just talking about a legitimate use of the drug. You know, I see it all the time, and it's,
There's no allowances made for that.
no. But I can tell you this, I've put many people through rehab. When some people, the doctors mess them up, I always thought that you ought to just sue your doctor, if your doctor
The
did.
doctor messes up, suppose the doctor's trying to do what's right. He can't perform surgery. He can't do, the only option he has
Right.
is the painkiller.
I don't know. Some of the doctors do mess up. Some of them don't need it. And what I'm talking about, yeah, absolutely.
There seems to be,
Absolutely.
everything seems to be on the person in pain, that they should reduce it, and you just suffer through it. I don't.
No, I mean, I can't answer that. If I could, President Obama would be calling me. He'd say, come on, Mr. Jones, help us with this health care.
I don't know painkillers I can get. I don't got taking any now.
One day I may need
I'm
them.
just looking for the future.
I understand. It's a really tough situation. It really is. I mean, I don't know the answer to it. Just me personally, of course, I have never been in such excruciating pain that I couldn't take it. But I won't take a pill unless I'm on my deathbed. I mean, I've just seen so much of it, I'm just not going to do it. Now, if I get to a certain point, I'm sure I will. But I just don't, I'm not into medication. I don't want to do it. I'm afraid I like it. With my personality, I'm afraid I'll take too many. Yes, ma'am.
I don't know if you can tell us or not because of privacy issues, but the founder you were talking of, was that Armco in
The
the
who?
case,
No,
in the
no,
case in
no,
Ashland?
it was not, no.
Okay.
And that was just a hypothetical. All right, what else? That it? All right, we're going to do a deposition with Dr. Crystal real quick, and it's in the back of your thing here. When you're finished with this, just keep your outline, but rip this off because this is an actual case going on. But I wanted you to see one and just leave it up here because I'll dispose of them today, okay? There's no privacy issue with it because I got the name marked out, and it is public record, but I'd just rather it not be floating around out in the where it is. This is a case where this gentleman is from down in eastern Kentucky. He's a really nice guy, hard worker, hard worker. He has worked many years in the mines. He's got a 12th grade education. He's a certified mine foreman. He's a certified mine electrician. He's right-hand dominant, okay? He hurt his right hand. He was involved in a crushing injury, and he busted his pinky all to pieces, and they couldn't get the surgery right. He had 2 or 3 surgeries. They finally got it right. He went back to work, okay? He went back to work and worked for about 1.5 years. Then all of a sudden he developed problems with his left hand. One of the doctors said it was from overuse for overcompensating from the right hand because he couldn't quite do it the way he used to do with the right hand. Other doctors said, that's ridiculous. He's got a little carpal tunnel that has nothing to do with his work or anything else. They released it and he should be fine. So after you get a carpal tunnel release, most of the times you should be okay. So he is now, the problem is he's like 58, 59. He's worked 30-some years. He's tired. He's worn out, okay? If I worked 30-some years in the mines and did heavy labor, I'd be worn out and tired too, okay? He just doesn't want to go, he doesn't want to work anymore. He's done. He's done. The question is, should we pay for it? He's working for friends of mine that are friends of his, okay? I've got the insurance case. You will note that there's a statement from the employer. I went to the employer, and there's a statement from the employer that says, whatever restrictions any doctor puts on him, we will accommodate. We want him back because of his knowledge in mining, even if he's just supervising other electricians. We want this man on the job. Because, gang, it's hard to find good people that are qualified in eastern Kentucky now. Most people aren't coming down there and going to work in the mines anymore. So if you got a good mine foreman, you got somebody in your mine, you better do everything you can to keep them moving. So I've got a case where the employer says, no matter what, we'll pay him and we'll keep him at the same salary. And he's making $60,000, $70,000, $80,000 a year. But he's tired. He's done, okay? So I sent him to a couple of doctors, and our doctors, like one of them, Dr. Prim, said 1 or 2% or 3% can work, no restrictions, nothing wrong with him. He's fine. He's right-hand dominant. That right hand's now okay. Left hand had nothing to do with it. He's already had his release. He ought to go back to work. I sent him to Dr. Jenkinson. He said the same thing. I sent him to another doctor. He said the same thing. He's also alleging a little psychological overlay, but that's not a major issue in his case. They sent him to Dr. Nadar, and Dr. Nadar's first report said he had a 3%, but then he went back and changed his report and said gave him 3% on the dominant hand. Then he went back and said, oh, I forgot to rate the overuse portion, so now he's up to like 22%. And he said he can't do anything. But when I took his deposition, he said, well, there's certain things he can probably do, and now that I see this employer statement, he can sure go back and be a supervisor, supervising men, if he wants to, okay? So that's the question, is if he wants to. Now the question is for a judge, is the judge going to total this person? Going to give him a 1% from one doctor, a 3% from another doctor, a 5% from another doctor? That's where it is. But he's alleging total disability. So I send him up here to Dr. Crystal, and Dr. Crystal does a complete exam, reviews all the medical records, and you know the only reason I'm taking this deposition is to show that he does not have a complete inability to perform work in the job environment. If the judge believes that, he doesn't get a total. He gets the 1, the 5, the 8. If the judge doesn't believe him, he gets a total, okay? That's the whole case. That's the case. This case should be settled, but we're not getting it settled for some reason. And I'm going to find out why very shortly. But anyway, so I've...
They want a total.
Yeah, because they want to... Well, usually we settle somewhere in between, you know, and that's what you do. So Dr. Crystal has seen this gentleman at my request. I'm going down to take his deposition. The court reporter, you all saw it if you did in the video, will swear Dr. Crystal. So you swear to tell the truth? He says, no, I always lie. And no, he doesn't. And then I will pick it up. Usually I would go through his qualifications to show how he was qualified.
That'll take a couple hours.
Yeah, that'll take 5 minutes. But in workers' comp, we don't do it because we all do this so much that all their CVs are on file down in Frankfurt. And if any judge doesn't know them, they can go look it up. And they all know us. I mean, all these players are the same. We're just changing the names and the circumstances, okay? So Dr. Crystal, I wouldn't ask his qualifications. That saves a ton of time. And then I'm very quick. If I'm not going to use it in a brief, or if I don't, who's the quickest lawyer you've ever seen on depositions?
Some fellow named Paul Jones.
Man, if I don't ask questions that don't need to be asked because I don't want to waste my time. And some lawyers get in there and they just want to ask thousands of questions, just hear themselves talk. I actually will get out a paper and start reading the paper. So when do you all quit? Leave me alone. So we've got him in, we've got him sworn, and here's how quick this deposition will go. Remember, I just want one thing. Is he totally disabled for any job? That's all I care about. The rest of it, I don't care, okay? During the course of your practice, have you had an occasion at my request to do a complete vocational evaluation on Mr. John Doe?
Yes, I did. Yes, I have.
What was the date of that evaluation, and tell the judge what it consisted of?
The date of the evaluation was November 7th, 2011. The evaluation consists of 3 parts. First part was to interview Mr. whoever, at which time I obtained background information regarding his age, education, employment, the nature of his injury, and what, in his opinion, limits or prevents him from being able to engage in the past or other work. Second component was to conduct vocational testing, the purpose of which was to determine his academic, intellectual, and aptitude abilities. And if it's determined he's unable to engage in his past or usual work, I'd be able to make recommendations regarding alternate employment or training. And then the third component is to review the background reports and medical information in order to determine the physical and or mental abilities of Mr. say Smith.
Subsequent to your exam, did you prepare and forward a very extensive and way too long report which summarized your findings and conclusions and your what you failed in this case?
Yes, I did.
And did you attach to it the DOT outline?
Yes.
I hand you up reports to be a copy of that and ask you if it is.
Yes, it is.
Would you allow the court reporter to have a copy of your report and mark as Exhibit 1 in the back of your deposition?
Yes, that'd be fine.
See, that way I get the whole report in immediately. I don't go page by page by page and bore everybody to death. Just stick the report in, the judge, then I'll hit the highlights on the report that I want to hit, okay? Are all the opinions in your report based upon vocational probability?
Yes, they are.
If a lawyer doesn't ask that question, either medical probability or vocational probability, they throw your deposition out because the doctor has to be able to testify within probability, not possibility. So if a lawyer doesn't do it, that deposition's tossed, okay? Some people forget to do it, but I always tell them, I said, ask that question so we don't have to come back up here. Doctor, part of your exam consisted of taking a history from this individual,
Yes.
and I believe he had a 12th grade education and also had mine foreman papers.
Yes, he did.
The only reason that's important, I want that judge to immediately know we're not dealing with somebody that doesn't have a lot of education, and it automatically pops into the judge's mind, well, if he's a mine foreman, he's passed some pretty stringent tests, and he's got a 12th grade education, he can handle himself, okay? So that's all I would ask about that. And doctor, did your history also reveal that in regard to his right hand, basically he broke his little finger,
Yes,
and in regard to the left hand, there's a questionable case of overuse?
that's correct.
So that summarizes the whole case. We got a broken little finger and a question of overuse. That judge is going boom, 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 okay? And did you also review a statement from the employer that said that they would do anything with any restrictions to allow this man to come back and modify their work?
Yes, I did.
Pretty nice, aren't they?
Yes, they are.
Doctor,
My electrician's a hard come by.
are you doggone right? Now, here's the question. Now, I've hit the little points that I want to hit, okay? Doctor, after doing your complete evaluation and after reviewing all the medical reports in this case, tell the administrative law judge whether you feel this individual is capable of performing jobs in and around the East Kentucky area, in and around the Kentucky area, and the national area, and why or why not. That's the only question I really care about. And then I turn him loose.
To summarize, based upon the most restrictive levels of physical functioning, Mr. Smith would have the ability to do work which does not expose his left hand to injury, as described by Dr. Jenkinson, and which does not require extensive use of his hands, Dr. Nadar, as well as alternate, less stressful work, parentheses, although Dr. Granica did not specifically state that the GAF of 51 to 60 precludes work activities, certainly would allow lower stress work activities. Based upon the most restrictive physical and mental limitations, Mr. Smith would be able to do a wide range of non-hazardous security, manufacturing work activities, clerical, cashier types of jobs, service jobs, call center work, mine attendant work activities, and related job areas, related occupational areas.
So even with the most restrictive restrictions that we have, there are still many jobs that this gentleman can do in and around the Kentucky and East Kentucky area.
In the thousands.
And what about from the rest of the medical? Let's say the non-most restrictive, then where are we?
If we look at the restrictions or lack of restrictions from Drs. Herb, Prim, and Sheridan physical, and Dr. Schraberg psychological, as well as Dr. Jenkinson, Mr. Smith is able to return to his past work as well as related and other work.
Now I got him going back to work. I've gone through the most restrictive, and he can still do things. Now, if you believe the other doctors, he can go back to work and do anything he wants to, okay? So I'm tying it all in. My last question is this. Doctor, the DOT, which you have attached, defines work as sedentary, light, medium, heavy, and very heavy. Is that correct?
That's correct.
Are there literally thousands of jobs within each one of these categories under the DOT?
Yes, there are.
And is this individual able to do a wide range of all those within most of those categories?
Yes.
I'm done. Okay? I'm done. He said he's not totally disabled, so there's many jobs he can do, even with the most restrictive activities. I'm done. If the judge believes it, it's a partial, it's not a total. Okay? Now, the other side's going to come back and say, I don't ever do the other side, so I'm not very good at it. I've only represented the industry all my life. Believe it or not, I've never sued anybody in 32 years. That's hard to believe, but I haven't. Dr. Crystal, did this individual give you some subjective complaints?
Yes, he did.
If those subjective complaints are believed by the administrative law judge, and now we're getting into his testimony, by the administrative law judge, is this individual capable of doing any type of work that he has done in the past or any type of work at all?
The severity of the pain complaints as described by Mr. Smith in terms of the pain being severe and at times very severe, based upon his description of the pain, would preclude work activities.
And that goes into what you were talking about, pain. And if the judge were to believe that that pain was true and real, and you saw what the test is, that you can use a lay testimony alone, then that now turns that back into a very dangerous case, or I turn it into a non-dangerous case. Okay, just those simple questions. And the other side would go into much more things, but that's basically exactly what they want to say. If they're smart, they'll ask those questions and get out of there, because if they start messing with him, he'll bury him alive. He'll bury him alive because he's that good.
But the pain complaints, those are things that the person will have testified to anyway. That's no surprise.
Right.
That's going to come out in the guy's testimony. So that's no surprise. And you go back to the credibility issue. If I then turn around and say, well, I don't believe the pain complaints, then my credibility or your expert's credibility is compromised. Of course, that's the obvious. The guy says he's in excruciating pain and can't, really do anything, has to lie down all day, and you say, well, no, he can work, then, that goes to your credibility, and that can have a spread effect to all the things that you've said.
And once, gang, just like in all of life, once that credibility is tainted, you're in trouble. You're in trouble. And if Dr. Crystal, see, that's why I would not come back and say, well, do you believe that thing of pain and all that bull? I mean, I'd like to, but I'm not going to because I'm not about to go at, to make him look bad. And he'd look at me and go, and I go, whoa. So I know not to ask that question. But if you ever get caught in a deposition and you get caught lying or you get caught doing some things you shouldn't do, you go too far out of bounds, all lawyers will remember it. Cases come and go, but lawyers are around for a long time. And when the credibility of a doctor or anybody else gets tainted, every lawyer in the state knows about it, okay? And then all of a sudden, they're going to say, Dr. Crystal, in deposition of so-and-so, so-and-so on page 6, did you say this? And then that could ruin him for every case. It could destroy his credibility in every case. So a doctor, and particularly Dr. Crystal and the medical doctors, have to be very careful. You know, there's a range within which you can testify. But when you start getting out of bounds, okay, that's when you get in trouble. Just stay within the ballpark. And he always does. All right, what else?
Any questions, Bill?
I hate to ask a question. But if I were on the other side, I would be tempted to counter Dr. Crystal's. I would agree fully with his assessments that he can do this, he can do that. But could I say, well, yeah, that's fine, but there are no jobs for Dr. Crystal to point out specifically where the jobs are that he can do this.
Oh, he can. I just didn't ask him. I was trying to get cut to the chase. He
Well,
can.
I wouldn't ask him.
Yeah.
I would cite the employment situation, say if I were in Casey County, I just use
Right.
that as an example.
No, I don't care.
I don't know
Yeah.
anything about it.
Well,
I've met a few
yeah,
people in Casey
that's,
County, always proud, but at any rate, could I just say, well, I fully agree with the assessment, and I would have my figures together that, in anticipation of his testimony, about the jobs that this guy could potentially do.
But remember now, we're not limited just to Casey County now. Now we're in an area, a regional area, with all kind of.
I have all that
Yeah,
too.
yeah, yeah.
Said the nearest job is 50 miles away. Toyota's not hiring.
Right.
Or UK's not hiring.
Well, the
I just
economy's
wondered,
not, the
could
economy's
that-
not
could
real
that
good
be-
right
Could
now.
that be used as a response?
Sure,
that
And
gets,
is it ever accepted?
very rarely.
that gets into the occupational disability concept of where you're located and, you know, jobs that might be in the area where you reside. So that brings in, you know, as we talked in Social Security, that's not a factor. Judge can consider whether somebody would be hired to do a job. And it's based on Social Security, the national economy. I don't think it's specifically that strong in worker comp, but I think from what I've seen, that usually is not a major issue. It might be asked for the benefit of the individual to see, well, the plaintiff lawyer will say, well, you see, I asked him, you know, what employers out there are hiring. And he said, well, you know, there aren't many in the county that you live in. Another part of that question has to do with getting a job and being hired, and whether someone would hire you or not typically is not a factor. Because people can go in, as you will learn next semester in the job placement class, people can go in and talk themselves out of being hired by an employer, by what they say, how they answer questions. And so that gets into subjective issues also. And so
Practice law is great.
part of your question also is the difference between jobs in existence versus current job openings. And those are also very different questions. No. Now,
Never.
there is a part of, there is a worker comp law, I think it's what is it, the harbor workers, longshore and harbor workers, where that's a federal law, where if you work on barges or in waterways in the U.S., the standard is much different. The standard for proof, as lawyers say, is such that vocationally the defendant has to have the expert identify specific job openings. And that's more difficult to do. Laura's been involved in some of that. But that's more difficult to do. In worker comp in Kentucky, you don't have to do that. You just have to show that there are jobs a person is able to do. And of course, you know, what I would say is, you know, when an employer has a job, the employer wants that job filled right away. So a job open in the morning, you know, might be filled by the afternoon. So the job market itself is very fluid. But yeah, people can get into that. Right, for the most part, in worker comp, despite what we just went through, vocational reports are submitted. There are very few depositions that I'm doing now in worker comp. I wish I'd do more so I could charge more, but.
What is your fee?
$200 per hour is what you asked, that's what it is.
Well, you're making more than me.
I would hope so. No. So, for the most part, they submit the reports, and the reason for that is because, worker comp is a closed system to a great extent. Everybody knows, what the issues are. You kind of know what the cases are, and so there's not, you're not in front of a jury trying to convince a jury, where you can get more into this than what you asked about, what are you being paid, and it looks like you're hired gun. Anytime I say $200 an hour, and I try to explain that, they say thank you, but when I would try to explain that would mean, well, I don't get that, I don't get that in terms of all the money. That goes into other things. It goes into, overhead, paying the rent. It goes into paying staff. It goes into paying for test equipment. Test supplies are very expensive. So, but they don't want to hear that part of it. But that's in front of juries. That's different.
Anything else?
All right,
I'm going to Pike County.
thank you very much. Appreciate it. Did a
No
great
problem.
job.
Thanks.
Okay. We're off the record.